It's officially 9 o'clock in the morning. Welcome to an oral argument session in the 5th District Court of Appeal. My name is Judge Jim Edwards. I'll be presiding. With me today are Judge Rand Wallace and Judge John McIver. We have one case on our Zoom docket this morning, and that's Anthony Litch versus Julie Mills, case number 22-2632. And we have 20 minutes per side. There's a clock that you should be able to see on the screen. I know at least one of you are very familiar, but I'll tell both of you. The appellant typically has 5 minutes rebuttal. If you want anything different, Mr. Shaneen, just let us know and we will change that. That is your total time on the clock, including your rebuttal time. You'll see the yellow light come on. If you don't seem to notice that, I may mention it to you to ensure that you have your rebuttal time. Ms. Mills, you'll have your full 20 minutes to make your arguments as you wish. The court may have questions for both sides, and please let us get our questions out and then we'll try to let you answer fully. If you have anything that might make noise like a telephone or computer, please make sure that's on mute, not the one you're talking with us on. But even during that time, if you're not speaking, please go ahead and mute yourself for now. And then when it's your turn, unmute yourself. If you forget, as we all do from time to time, we'll let you know. But that way it avoids any kind of feedback. So with no further ado, Mr. Shaneen for the appellant.
Thank you, Your Honor. May it please the court, and good morning. I would like to reserve 7 minutes of my time for rebuttal.
7?
Thank you, Your
Okay.
Honor.
All right.
And with that, my name is Nick Shaneen. I am the counsel for Tony Litch, appellant in this Uniform Child Custody Jurisdiction and Enforcement Act case. That's what this case is about. It's about proper enforcement of Florida statutes, and those Florida statutes are the same Florida statutes that have been equally matched in 48 other states, including the state of Illinois. And it is critically important for those statutes to be properly enforced in a uniform manner throughout those states in order for the comity and the very important principles that are stated within that act to be applied as echoed frequently by courts of this state, including the Florida Supreme Court. I would like to start with this court's question. I want to thank the court for that question, and I mean that truly, because as a practitioner, when there's going to be something outside of the ambit of the briefing that this court is interested in, getting a question in advance certainly aids the process, and so I thank the court for that. And that question was, what, if any, effect was there for the fact that Mr. Litch timely and properly appealed the Florida court's declination of jurisdiction, but did not engage the Illinois appellate courts in an appellate effort in Illinois on the Illinois court's assumption of jurisdiction? And it is an interesting question, but it is one that is ultimately answered with the answer that there is no effect of any sort on this court based upon the actions of the Illinois court or the decision to try to engage in two parallel streams of litigation simultaneously that would have resulted in exactly what the UCCJEA is designed to prevent. That the foundational premise of that is to stop what the Supreme Court in Florida called the chaos that existed before the UCCJEA of multiple states imposing their different views of jurisdiction and having parties unable to know what they should do or where they should do it. So the answer is no. Florida is the court that should have jurisdiction, and Florida is the court that is the proper reviewing entity for a Florida court's decision. I have forwarded to the court a couple of additional cases. Those cases are not anything that are groundstaking or actually, involve the precise issue of, was there some sort of procedural issue for not appealing the actions of another state, but they do go to that issue. And the first of those cases, the Florida case, NB versus Department of DCF, and that was 3rd District 2019. And that court had a UCCJEA matter before it. And in that case, the court specified that any failure of the sister court to adhere to the proper procedural requirements as alleged is not within the purview of this court. That this court, being a Florida appellate court, should review what's before it in the Florida courts and make a ruling upon it. And if California or Illinois messes something up, that's on them, but it doesn't change the fact that Florida needs to tell a Florida court if it has jurisdiction or it does not. In this case, it does. That case, interestingly, cited a lot of cases from across the nation as support for its principles of jurisdiction. And the lead case, though, that they cited amongst those was a Maryland appellate court case from 2018 called Krebs v. Krebs. And the Krebs decision, I wouldn't cite the Krebs case to this court if it hadn't already been utilized by a Florida court for the principles that we're talking about here. But it is a highly persuasive case. It involved a tug of war between Maryland and Arizona. And in that case, the appellant in candor told the court that as the home state, the decision that Arizona was an inconvenient forum and that Maryland was a more convenient forum must be made by the Arizona court, who was the home court, the original court that had that exclusive continuing jurisdiction that the UCCJEA is all about. That was a more convenient forum, must be made by the Arizona court and not the Maryland court. And then the court said, we agree. And then they explained, though, that because of that, that the appellant was making her arguments to the wrong court, that this court, meaning the Maryland court, does not have the power or authority to conclude that the Superior Court of Arizona erred in applying the UCCJEA if she's aggrieved by and here's the important part, if Ms. Krebs was aggrieved by that court's declination of jurisdiction, the appropriate review would be in the appellate courts of the state that declined jurisdiction, in that case, Arizona. You've got to go back to the home state to ask for the court to take jurisdiction. And if that court fails to take jurisdiction, to appeal in that state. So the question is
so,
certainly, yes.
Question. Obviously, the trial judge in this case went on the record and made a statement that I believe the statement was that because the child had been settled into the state of Illinois, that he would believe that jurisdiction would be the appropriate place for the child to reside. I think what you're saying here, the relief that you were seeking is to have the trial court properly hold a hearing and make the requisite findings as far as ultimately it may be to cede jurisdiction to Illinois. But I believe what you're requesting, and correct me if I'm wrong, is that there needs to be a properly noticed hearing with the parties having the ability to be heard in Florida before a determination could be made at that, although that determination could be made at that same time in that hearing. Is that correct?
Judge Wallace, you've got our relief request precisely correct. We are not seeking this court to say that Florida not only has jurisdiction, but must retain jurisdiction at all costs. It's simply that Florida does have jurisdiction, and Florida's court must exercise that jurisdiction at least until one of the exceptions to the UCCJEA happen. And the primary one that this court's alluded to there is a valid and fully vetted determination whether Florida has become an inconvenient forum. And that is precisely correct, that what should happen is this court should remand, inform the Florida court it has jurisdiction, and then the Florida court may do exactly what this court just outlined, a proper hearing under Florida statute 61-520 for inconvenient forum. It should be an evidentiary hearing. There are a couple of Florida Supreme Court and other cases, the Johns case, for example, that says an evidentiary hearing would be appropriate for that. The parties would be properly noticed and have the opportunity to do a full argument. And then at that time, the court would then mandatorily go through each of the 8 factors that are listed in section 61.520. These are not optional factors. These are mandatory factors, and there are 8. And the court says at least those factors. The court can add additional factors if it would like, but if a court fails to go through that full process, then the court has not properly exercised its jurisdiction and then divested itself of that jurisdiction by way of a determination of inconvenient form.
And what is the standard of review going to be in that hearing that we're going, if ultimately, if there is an appeal, is it different factually versus the legal application of the law? How is that going to take place down in the trial court?
Certainly, Your Honor. It's the arguments that we're having here today are de novo because we're talking about the interpretation of the UCCJEA and application of law. So this is a full de novo review, but this court is exactly right that there would be a different standard of review should that determination that's ultimately made by a Florida court then be subject to future appeal, because then after the court does that and goes through the proper process, assuming that the court applies the law correctly, if it's about whether the court balanced and weighed the facts and the evidence and the testimony the court hears, that's an abuse of discretion standard. And in all candor, I would advise my client, if that Florida court does not rule in his favor after doing all of the proper things, that appeal would be very difficult because of the abuse of discretion standard that would apply. But in order to get there, we have to get there. And I would posit to the court that the circumstances are such that Florida should maintain jurisdiction after it exercises that jurisdiction. There are lots of compelling reasons why it's important for Florida to maintain that continuing.
Counsel, let me interrupt you before we get to the appeal of the hearing that hasn't taken place yet. The way you've briefed the case, as I understand it, and the application of the UCCJEA is whatever the first court is that enters a custody order properly has jurisdiction and maintains jurisdiction. And the fact that a court in Illinois and a judge in Florida may look at a different section of the law to talk about home state and where the home state is, that's not how it operates. The original court is the one who must make a decision itself. Is that correct?
Your Honor, that is absolutely correct, and it is well backed by a ream of precedent, and that precedent was cited through the briefs. But the Yergel v. Yergel case is foundational. The 1990 Florida Supreme Court case that made it abundantly clear that even though the kids are were in Georgia, Georgia was the home state, but they moved to Florida for years. It does not change the fact of Georgia's, in that case, exclusive continuing jurisdiction. And that's the phrase, it's exclusive continuing jurisdiction. Once it's established in a Florida court that they have jurisdiction over a family law case, it has to be exclusive and continuing to Florida. And yes, there's provisions for temporary emergency jurisdiction that allow for another state to do something on an emergency basis. And that's the way it needs to be, because, the children need to be protected in the instances of things that go left or right. But even in those instances, the cases make clear that temporary jurisdiction is temporary, and that it must be vested back to the home state's jurisdiction. In this case, plain language of the statute, and this isn't just Florida statutes, it's every one statute, with the single exception of Massachusetts for whatever, that every one of those states applies it the same way. And that same way is that the state where that original action was determined by a court that determined child custody issues must have that continuing exclusive jurisdiction. So for each of the reasons that we discussed in the briefs, it is important that this court, put that out to the lower court, put that out for practitioners and parents to follow those guidelines, so that these laws that are supposed to be uniformly applied are uniformly applied, and we don't devolve into the chaos that existed before the UCCJEA made a uniform application of the law for each of these states to follow. With that, I see I've now hit my rebuttal time, and I would like to reserve that time for.
All right, that's fine. Ms. Mills, we'll turn to you.
Hello.
And when you're ready, go ahead.
Okay, Your Honors, I do apologize. I don't have a long speech. But my argument is that the court in Florida had jurisdiction. They exercised their rights for the parenting plan, whatnot. We were doing a bunch of court prior to that, and they had jurisdiction. And then we all got notified by judges down there that we needed to do the UCC JEA conference. And everybody did memos, everybody got notified, Illinois and Florida. Everybody had plenty of time to prepare for that and gave their statements during that. And both judges agreed that the jurisdiction was no longer Florida. And courts change jurisdiction all the time. So I believe they did it the right way. I don't know anything different. We were just going with what the judges had told us to go along with, to get the jurisdiction changed because it was no longer Florida.
All right. I do have a question for you. Under Florida statute, section 61.515, the jurisdiction is to remain with the original court that does the first custody order, which would be Florida. I don't think there's any disagreement. Florida was the original court. And that it keeps that jurisdiction until one of several things happen. And that's the child and the child's parents, which is plural, meaning both parents have to leave the state, or there has to be a determination that none of them have a connection to Florida, or that it's no longer a convenient state. Here, as I understand it, the Florida judge made the comment, looking at the history, the brief history, the child's been up with you for 6 months or longer. Therefore, under the definition of home state, Illinois is the home state. My concern about that's not one of the factors that's listed. So if it's not one of the factors that's listed, how then was it proper under 61.515 for the Florida court to cede jurisdiction away to Illinois?
Okay, I do apologize. I'm sorry. I'm trying to
You have
go
plenty of
through all
time.
it. I tried to pull up all the transcripts and everything prior. I'm just trying to find the correct one. Because I do believe in there that more than just 6 months of residence up here was listed. I want to
agree.
double check.
No, that's fine. I agree. The judge said the child seemed to be doing well, and it's in the best interest of the child to be up there. I think statements like that were made, and I don't think anybody is taking issue that those statements were made. But the statute lists certain specific factors that have to exist or no longer exist before the original court would cede jurisdiction. And again, one of those is both parents are gone, or there's no longer any connection to Florida, or Florida's become an inconvenient forum. I mean, there are others, but the fact that the child has been up in Illinois for 6 months, or is doing well in Illinois, or some of the other statements that it's in the best interest. The best interest of the child, obviously, is everybody's overarching concern. But in terms of which court should make the decisions on that, that doesn't come into play in terms of 61.515, does it? And if it does, tell me what section of the law that is.
I don't have those pulled up. The sections that you're talking about, I'd have to go back on like the I don't know what it's called, where they have all the laws listed.
Right.
I don't want to waste your time. I can try looking for it.
Well, I mean, I've looked at it, and again, there are specific factors, and you can look at it after we're offline here if you choose, but there are specific factors, and the factors that the two courts talked about did not really touch on any of the ones under 61 0.515, at least as I could tell. And that's what my concern is. This is the statute that controls how jurisdiction moves from one court to the other. And the factors that the judge in Illinois and our judge here in Florida discussed, while important in the big picture, don't really talk to the factors you look at over who has jurisdiction and whether jurisdiction should change. So that's my concern. And as Judge Wallace mentioned, if we decide the appeal against you and in your former spouse's favor, it doesn't mean that the case is over, that forever Florida has jurisdiction. It just means that there would then be another hearing, which may or may not be different in kind and may or may not result in some different way. But in terms of looking at that statute that talks about how jurisdiction transfers, that's my concern.
Well, I think, and without looking at it fully and just off of what you said, based on residing parents and the child, yes, father lives in Florida and has not moved. I've been in Illinois and have not moved since the divorce. So I don't see how it could go one way or the other, because I mean, if he's on his side fighting, he's been a resident of Florida, so it should stay there. Well, I've been a resident in Illinois, it should stay here.
All right. And you have plenty of time. If there's anything else you want to say, feel free. Don't feel obligated to use all your time, but it's your time to use as you choose.
I honestly, I think everything was done properly. Had, it's gone differently, things not be completely exercised, like, the judge's opinion or what he thought, either one of them, or what either one of the parents' parties had thought, our input or the memos. I can understand that. And part of the argument that I did see in there, that there was no, notification, there's no room to have their own arguments in front of the judge or evidence, and that was all presented at the conference, the UCCJA conference.
Ms. Mills, just kind of as a follow-up to what Chief Judge Edwards was saying is, and I think Mr. Shaneen touched on in his presentation, because of the situation, because it's family law, because the appellate court doesn't have the benefit of having the parties always in front of them, and the judge maintains regular contact with the families throughout the process, there's a lot of deference given to the trial judge. And there's a lot of, the trial judge has obviously the overriding best interest of the child in it, as Chief Judge Edwards touched on. So, when it goes back down, we just need to follow the procedures. If it goes back down, just need to follow the procedures, and the procedures are there for a reason. And there's a reason why there's a specific list that needs to be at least considered, or in the trial judge to touch on why certain factors were or were not found, or were not considered. So, and then it's not limited to that list. So, it doesn't mean it's over. It just means we need to abide by specifically what's laid out as far as how to follow the statute. So I hope that provides some clarification.
Yes, greatly appreciated. And I totally get that. That's understandable. I don't think that and everybody makes mistakes, and I understand that. I don't think that he would intentionally do something like that or make a ruling without having proper knowledge of the family in the case and everything that's gone on in the case. And, obviously the law, he's a judge.
Does that conclude your presentation, Ms.
Yeah.
Mills? All right.
Yeah.
Mr. Shaneen?
Thank you, Your Honors, and thank you to Ms. Mills that she's been I've worked with pro se people on appeals plenty, and she's been absolutely one of the most pleasant ones to work with. So I appreciate that. And I will try to match her in yielding time back to the court. I think that this court has properly analyzed the plain language of these statutes, and that plain language. Sure.
I would like to just, if you would, let's take Ms. Mills' argument just at face value, that things were actually done properly. So to arrive at that, I think what they're saying is that the judge, based upon best interest of the child and where the child is, without drawing us a direct map, arrived to the idea that Florida is no longer the convenient form or is an inconvenient form for those reasons. Can you just briefly touch on why that is or is not the correct approach?
Your Honor, I think Judge Edwards has already, stated out what those factors are, and Your Honor's correct that under the most benign view of what occurred at that Illinois court proceeding, there was no taking of evidence, there was no opportunity to vet each of these 8 factors, and there was certainly no discussion of the 8 factors. That I agree, Your Honor, that that was the we got that the Florida court didn't think that jurisdiction was proper in Florida any longer, but both judges were talking about things that belonged in an initial determination of jurisdiction proceeding. Both judges talked about 6 months, and no one's disputing that the amount of time was more than 6 months. The reasons why that length of time was there are certainly subject to plenty of debate and testimony. But the judges were very much focused on the same kinds of considerations, or not the same kinds, the considerations that would apply for an initial determination of jurisdiction. It is critical for application of the UCCJEA that home state is home state, and that home state have the exclusive continuing jurisdiction. And in order to yield jurisdiction by that statute, it is critically important that there be an actual hearing that's designated. This is going to be a hearing on inconvenient form. And this hearing is going to allow for the testimony and evidence regarding each of these factors. And then a ruling must be given that cites those factors. And there are Florida cases cited in the briefing that reversed for solely the fact that they didn't include not including factors, but not including 1 or 2 factors of the 8 factors. It's that important that we know that the judge considered each of these factors. And my client very much believes that when a proper consideration of those factors occurs, that a judge would agree that Florida should maintain its continuing and exclusive jurisdiction. But as we've discussed, that is not what we're arguing here on appeal. That hopefully will never be a subject that will be before this court because it should get resolved at the trial court on remand. But in order to be stewards of the law and to consistently and faithfully apply the plain language of the statutes, and again, it's not just Florida statute, this happens to be everybody's statute. We must properly apply the language, and that language in 515 says Florida has the continuing exclusive jurisdiction, and in 61-520 it lists those factors that must be followed. An evidentiary hearing should occur on remand, and the parties have their full opportunity to give those arguments and testimony that would support whether Florida or Illinois, and it's really not about Illinois, it's whether Florida has become an inconvenient forum. That will obviously involve discussion of occurrences in Illinois, but it must be the Florida court making this determination. And this judge ceded jurisdiction improperly under the statutes. And for each of these reasons, appellant Tony Litch respectfully requests this court to reverse and remand with the instructions that this court has already discussed. Thank you for your time this morning.
Great. Unless my colleagues have further questions. All right, thank you. The case was well briefed by both sides and well presented by both sides. And we will be in recess and to consider the case. Thank you.
Thank you, Your Honor.